Assalamu alaikum and hello to everyone and welcome you all in the sixth week of our course that is the International Criminal Law. So students, in today's lecture I'm going to deliver my very important lecture on the topic that is the national prosecution of the international crimes. So in this chapter, in this topic, we are going to discuss very much important topics which are related with the uh, prosecution and investigation of the crimes which are the nature of the international liability. Students, criminal law and proceedings are at the heart of the state sovereignty and cooperation in criminal matters is a voluntary undertaking. A state is not obliged to cooperate with others in a criminal matters unless it has agreed to do so. But over the time, a narrow view that criminal law, including its effects, is local in nature, has given way to an ever-growing need for an actual regulation of the international legal cooperation. Influential factors in this regard are increased cross-border activities, including the commission of the crimes, international terrorism, and the development of the human rights. International crimes are of concern to all states and therefore lend themselves to the efforts at cooperation. A commitment to cooperate in the form of extradition in the alternative to prosecution in accordance with the audit judiciary, which means either extradite or prosecute principles when applicable to the states. Cooperation is particularly important when the state is exercising jurisdiction over crimes committed abroad, but may also be necessary when a state is investigating and prosecuting crimes committed on its own territory. Prosecution of genocide, crimes against the humanity, and the war crimes is no exception. But international law, treaty, and custom has not yet developed a special regime for the state-to-state cooperation concerning these crimes. One must therefore resort to general principles and the provision of the international and domestic law on the international cooperation in criminal matters in relation to the ISTY and ISTR and ICC International Criminal Code. Therefore, students, in today's lecture, we are discussing topics related to the national and international prosecution of the international crimes. But here is the first topic. In the meanwhile, beginning with the national prosecution of the international crime. Students, international crimes are mainly intended to be prosecuted at the domestic level. Although the 1948 1948 Genocide Convention expected a possible international penal tribunal as may have jurisdiction with respect to those contracting parties which shall have accepted its jurisdiction. The International Criminal Court regime, through its system of complementarity clearly sees national courts as the courts of the first resort. Uh, Students, although the 1948 Genocide Convention expected a possible international penal tribunal as may have jurisdiction with respect to those contracting parties which shall have accepted its jurisdiction, the International Criminal Court regime, through its system of complementarity, clearly sees national courts as the courts of the first resort. This has been described as an indirect enforcement of the system whereby international criminal law is to be enforced through national systems. National prosecutions are not only the primary vehicle for the enforcement of the international crimes, They are also often considered a preferable option in political, sociological, practical, in legitimacy terms to the international prosecutions. But although the word pledged after the Second World War, never again to allow such atrocities to occur. They continue to be committed in many places around the world, and domestic prosecution are light. Indeed, um, the international criminal jurisdiction are an answer to the immunity that generally exists domestically. This lecture will address the international obligation in this regard and some major legal issues that arise concerning national prosecution of the international crimes. Among the complicating factors, insufficient legislation, nebis in idem, double jeopardy, and the statutory limitation are addressed here, while amnesties are dealt with in next upcoming lecture after the midterm, and immunities. Also, we will discuss in upcoming lectures after the midterm. When we discuss a lot of topics in final stage, we will discuss the amnesties and the immunities. So, students, here's the next topic of our today's lecture, that is the national prosecution of the international crimes that are the subject of this course and this lecture. War crimes have been regulated in domestic law the longest and have been prosecuted most often. The quite reluctant prosecutions in Germany and Turkey after the First World War, the Leipzig trial and the Istanbul trial in the 1920s related to the war crimes and were conducted under the domestic laws. No conflict has generated as many national prosecution as the Second World War. Sometimes for the international crimes, but in many instances for ordinary crimes under national penal law. Apart from the thousands of the cases in Germany, many other European states have instituted prosecutions. The most well known are the French cases against the Calius Barbie, head of the Gestapo in Lyons, Paul Tovier, pro-Nazi militiaman, and Maris Papon, a high-ranking official of the French Vichy regime, who were convicted for crimes against humanity in 1987, 1994, and 1998. After very long proceedings plagued with the difficulties. In the United Kingdom, after the many prosecution directly after the war, only one Second World War case, R versus the Souvenir, has resulted in a conviction for war crimes in the recent past. Second World War crimes have also been prosecuted elsewhere, most notably by Israel, the seminal Eichmann case. It is not only the important issue of the jurisdiction, including the exercise of the jurisdiction upon abduction of the accused from another state, but also criminal defenses, the superior orders, and the act of the state doctrine, and the principle of the non-retroactivity of the criminal law. Adolf Eichmann stood trial for crimes against the Jewish people, crimes against the humanity, and war crimes. He was found guilty, sentenced to death, and executed in Ramallah prison in 31st May 1962. Jurisdictional issues were also considered when United States courts decided to extradite John and Damon James Duke to Israel to stand trial for the war crimes and crimes against humanity. Before the Israeli courts, however, evidentiary matters came to the forefront, and Dame Jen Juk was finally acquitted because of the doubts in respect of his identity. As the concentration camp guard, even the terrible and Terribilenka. And in 2009, though Damon Jen Juk was extradited to Germany to face the trial for his wartime activities. Other interesting cases are the Canadian Finta case, where very strict mental and material requirements for crimes against humanity and war crimes are introduced. And the Australian Polyuk case, where the constitutional validity of the war crimes legislation was challenged with the respect to the jurisdiction and retroactivity. In both cases, evidentiary insufficiency, in part owing to the length of time between the events and the trials, mean that they ended in acquittals. Conflicts after the Second World War did not produce many national criminal proceedings. A few examples are the U.S. court-martials concerning to the infamous My Lai massacre during the Vietnam War, albeit for the domestic rather than the international crimes. Some cases in Romania and Ethiopia where reference was made to the genocide. A short trial in Cambodia of Pol Pot and Hamir Raj in 1979, and preparations for prosecution of the crimes committed during the 1971 Pakistan-Bangladesh war. It was not until the 90s, with the renewed focus on the international criminal justice in general and establishment of ad hoc tribunals in particular, that the frequency of the national prosecutions increased. This is particularly true in Rwanda and the state of the former Yugoslavia. Rwanda introduced new legislation on the genocide in 1996, dividing genocide into three categories based on the gravity of the crime, carrying different penalties, and started a large number of the prosecution, but with a huge number of detainees awaiting trial. Said to be more than 1 lakh people, the criminal system had to be reformed, and traditional courts were introduced in 2001. Nearly 10 years on from the creation of these semi-formal courts, the backlog of the cases and the standards of the justice they met out have caused concern. In the former Yugoslavia, the Dayton Agreement laid the ground for interaction between the ISTY having primary jurisdiction over the relevant offences and the national authorities. These relationships have improved over time, and the ISTY has referred cases where no ISTY indictment was issued in Croatia and Serbia. With respect to the Bosnia and Herzegovina, a special scheme applied called rule of the road, whereby the ISTY prosecutor in effect waited national cases before a domestic arrest warrant for the war crimes was to be issued. The latter scheme ended in 2004 when the ISTY stopped issuing new indictments, and the state authorities in Bosnia and Herzegovina took over the reviews. As part of the completion strategy of the ISTY, cases where the ISTY has issued an indictment can now also be referred to national jurisdiction. A number of cases have been referred to the Bosnia, Croatia, and Serbia under this scheme, although it now appears to have stalled. In addition, prosecution of the crimes committed in the Rwanda and the former Yugoslavia have taken place in third states such as Austria, Belgium, Denmark, Germany, Sweden, and Switzerland. For example, the Tadic case originated as a domestic case in Germany but was taken over to the ISTY, while the Buter 4 cases in Belgium proceeded after the ISTR had declined to exercise jurisdiction. The trend has extended beyond these two conflicts. A number of the cases, often based on the private complaints, have commenced in the domestic courts, particularly in Europe, regarding the different conflicts all around the world. In some countries, however, for example, the United States and Canada, denaturalization and deportation under the citizenship and immigration legislation have been referred to criminal prosecution. Specialized domestic courts for the international crimes, sometimes referred to as the internationalized courts, have been established in some countries with the international assistance. National prosecution of the international crimes have been highly selective, and generally states have been unwilling to prosecute their own nationals. There are examples to the contrary, however, and numerous post-Second World War prosecution of the nationals in the West and East Germany, the more recent prosecution in the former Yugoslavia and Rwanda, as well as the court martials in the US and UK of the number of the soldiers for the abusing of the detainees in Iraq, are notable exceptions. A high degree of the selectiveness within one and same conflict may project the message that all other activities were legal, or the non-prosecuted parties acted in an uh, ir- irrep- uh, irresponsible way. The political willingness to pursue national prosecutions is decisive. A case regarding the crimes committed in the prosecuting state may well end up putting the state itself on trial. The Barbie trial, for example, led to the embarrassing questions about the French state's collaboration with the Nazis and the commission of the international crimes in conflict in the Algeria. There are also other political considerations which either prevent national prosecutions altogether or make them highly selective. Serious questions of the legality present themselves: selectivity, vagueness of the law, retroactivity, and very long time periods between crime and prosecution. The better ambivalent feelings that exist also have an impact on the legal mechanism and principles relating to the obligation of the states to prosecute or extradite the perpetrators of the international crimes. Another problem is that national courts often expose uneasiness and insecurity when dealing with the international crimes. For example, national courts frequently refer to the customary international law but without an accompanying attempt to demonstrate the exercise of the such norms. Also, the legal reasoning in the sum of the judgments has been criticized as lightweight and generally superficial, at least when compared with the ISTY and ISTR judgments. These two judgments are put the question mark on the uh, national prosecution to investigate the crime within the domestic capacity. The obligation next, students, our next topic, that is the state obligation to prosecute or extradite. As earlier I mentioned the Latin maxim, which means any harm or any wrong has been committed, which is the come in the principle of the international crime. Then the state obligation to prosecute or extradite. So, what are the treaty obligations? A number of the international treaties which address the international or transnational crimes oblige the state parties to investigate and prosecute the offense in question or to extradite suspects to another state party willing to do the so-called auditory and audijudicary to extradite or prosecute principle. Examples can be found in the four Geneva Conventions and Additional Protocol Number 1, covering war crimes that constitute grave breaches under these instruments. The provisions are phrased in the imperative: each high contracting party shall be under the obligation to search for the persons alleged to have committed or to have ordered to be committed such grave breaches, and they shall bring such persons, regardless of their nationality, before its own courts or hand them over to the another high contracting party. For the serious violation of the Geneva Conventions, which are not grave breaches, the principle does not apply under the treaty scheme, but states still have a right, although not a duty, to prosecute such violations. The principle also exists in the 1984 Torture Convention, the Convention on the Enforcement of the Disappearances, and many terrorism-related treaties. Such treaty clauses are often, although not entirely accurately, considered as allowing states to exercise universal jurisdiction, and normally phrased in the mandatory terms. And newer provisions require states to submit cases of the obliged violation to the competent authorities for the purpose of the prosecution, which is which is a wording that takes into account modern fair trial rights such as the presumptions of the innocence, but which should not be understood to lessen the duty of the prosecute if the evidence is there. One should also note that many civil law jurisdictions provide for the compulsory prosecution when an evidentiary threshold is met. However, the obligations are only applicable between the parties to the particular treaty. The 1948 Genocide Convention, on the contrary, includes an undertaking by the state parties to the prevent and punish genocide, but the jurisdictional scope is restricted to the courts of the state and territory of which the act was committed. And there is no explicit auditory and judiciary provision. However, some argue that convention may be read to include an obligation to prosecute or extradite. Support for broader duties than those explicitly set out the convention has also been sought in international criminal justice jurisprudence, but such conclusions have been questioned and obtained little in the court in the merits phase of the Bosnian genocide case. The court expressly saw the obligation to prosecute as a territorially limited, although the obligation to cooperate with the relevant accepted international criminal tribunals was considered not to be limited where fugitiveness are found on the territory of the state. In the latter situation, the court seemed to accept that prosecution of the extraterritorial instances of the genocide would suffice to fulfill this duty, probably on the basis that they were thinking of the complementarity and international criminal court domestic prosecution of the crimes against the humanity is not treaty regulated except for the torture and enforced disappearance is a separate crime. And so in this related another topic which is the human rights law obligations. So what are the human rights law obligations? As well as treaties explicitly covering international crimes, some have argued that since states have duties to respect and ensure the rights granted in the various human rights convention, it could be that the latter clause implies a duty to prosecute certain serious violation of the human rights. All acts constituting genocide and crimes against the humanity would be serious violation of the human rights when governments are responsible for them. As would most war crimes, this may be supported by some case law from the Inter-American Court of Human Rights. In particular, the Vasquez Rodriguez versus Andrews case, and more recently the Barrios Altos case, which takes a very dim view of the amnesties. It is difficult to say, however, that these cases on the positive duties under the Human Rights Treaty can be read as creating an absolute duty to prosecute all criminal crimes in all circumstances. Cases from the inter-American system are in advance of the jurisprudence of those of, for example, European Court of Human Rights and Human Rights Committee, and responded to the specific circumstances the inter-American institutions were dealing with. Therefore, the jurisprudence of the Inter-American Court should not be borrowed directly in its uncompromising formula and legal reasoning by other human rights bodies for situations which are structurally different. So, students, these are the topics which we have discussed after the short break after the